In our industry, we often hear and read about stories of buildings that are beset with dissension, not only among unit owners and shareholders, but also among board members themselves. Over the last year, we've been fortunate enough to work with a group of unit owners at the Sheffield condominium who, when faced with dire circumstances, banded together and were able to effectuate major change for their building and right their ship. In the spring of 2009, a small group of unit owners discovered that their sponsor had not paid common charges in over 18 months and was delinquent over $5 million in the payment of common charges. They discovered that there were millions of dollars of mechanics liens filed not only against the sponsor-owned units, but sold units as well. They discovered that the sponsor had, on over 40 occasions, invaded the reserve fund and used reserve fund monies for other projects unrelated to the Sheffield. They discovered that the sponsor intended to complete amenity space materially different than what was marketed and disclosed in the offering plan. No construction had taken place in the building for months. They were in dire circumstances. Our firm was retained, and we immediately started an investigation of the condominium's books and records and tried to get a true picture of what the financial snapshot of the building was. What we found was incredibly disturbing. Millions of dollars were owed to vendors. As I mentioned, there were over $5.5 million of unpaid common charges. Late fees were not imposed. Liens weren't filed against the unsold units because the sponsor, in addition to controlling the board completely, also had its affiliate managing the property as well. With regard to the reserve fund invasion, we filed a complaint with the Attorney General's office and sought their intervention. They have an ongoing investigation with regard to the violations of the Martin Act. In order to protect the association with regard to the unpaid common charges, we brought an action seeking to compel the board, the sponsor control board, to file liens against the unsold units. That litigation resulted in a settlement whereby the sponsor was obligated to pay common charges in the event of a recapitalization or a bulk sale of the unsold units. Ultimately, within months after our involvement, there was a foreclosure of the sponsored debt by a mezzanine lender and the eventual sale of the unsold units to a new sponsor. We assisted in effectuating the smooth foreclosure process and ensuring that sponsor disputes between the partners of the sponsor entity did not hinder or obstruct the sale to a new sponsor. Today, a unit owners meeting has been noticed by the new sponsor. Board representation will still be sponsor control, but there will be unit owner representation on the board before the statutory period requires it. And the common charges have all been paid, and the vendors have been paid, and the liens have been removed. This could not have happened without a unified group of unit owners who not only put together the funding necessary to get the professional advice needed to effectuate these changes, but also worked tirelessly in getting people to join the group, letting people know what was happening, providing regular updates via email, meetings in a building across the street, and even going door to door. It's truly an example of what people, neighbors who work together can accomplish if they put their minds to it.